The leak of this information was made possible by E.
All right, so we are on record. Good morning, everyone. Today is the 7th of October, 2021. This is an admissibility proceeding concerning an individual by the name of Chelsea Elizabeth Manning, who is present today by a video conference. My name is Marissa Musto. I'm a member of the Immigration Division. I'll be reviewing the matter today. And we do have with us representatives for the Minister, Mr. Anthony Lashley and Madame Josée Barrette. And representatives for Ms. Manning are, excuse me, Mr. Joshua Bloom and Ms. Lex Gill. This is a public proceeding, and we also have several observers participating today, or actually just observing today, who are connected to the proceedings. As I said, they are simply observers. They will not be implicated in the proceeding in any other way. And I would ask that they please remain off camera and muted the entire time. Thank you. So we've already verified that the sound quality is okay and everyone can hear each other properly. I'll just briefly state the reason why we're here today. So the minister has requested an admissibility hearing concerning Ms. Manning. The allegation that is being made is that she is an individual who is inadmissible to Canada pursuant to Section 36(1)(b) of the Immigration and Refugee Protection Act. So what I'll do is I'll formally read that into the record at this time. So the minister is alleging that there are reasonable grounds to believe that Ms. Manning is a foreign national who is inadmissible on grounds of serious criminality for having been convicted of an offense outside Canada that, if committed in Canada, would constitute an offense under an act of Parliament punishable by a maximum term of imprisonment of at least 10 years. So that's the allegation that the minister is bringing forward. It's their burden to demonstrate that this allegation is well-founded. Normally, if a person is inadmissible to Canada pursuant to Section 36(1)(b), the law requires that we issue a deportation order against that individual. Now, I'll just state briefly for the record that there was an interlocutory decision rendered by this panel on the 4th of October. The minister had made a request to postpone the proceedings until such time as Ms. Manning could be in Canada, arguing that in order for a possible removal order to be enforced, that she would have to be physically present in the country. Just briefly, that application was denied. The panel concluded that we do have jurisdiction, contrary to what the minister was arguing. So obviously, in the circumstances of Ms. Manning, if a deportation order were to be issued, the consequence, since she is already outside Canada, the ultimate consequence is that she would not be allowed to return to Canada without previously obtaining authorization. Now, that being said, counsels today have indicated prior to the proceeding that they wish to proceed slightly differently, I guess I'll put it that way. They have indicated that they will be making detailed submissions in writing after the proceeding is concluded, that they each side wishes to make an opening statement in regards to an outline of their position in this case. They still wish to call witnesses, so I understand that Ms. Manning is being called as a witness today, and there will also be a second witness called by counsels for Ms. Manning, and that is Professor Heidi Matthews, I believe.
Yes, correct.
Right, thank you. So there was just one issue that the parties didn't entirely agree on how they wish to present the evidence. Counsel Bloom was indicating that they were asking to make their opening statement first and question Ms. Manning first, and then obviously give an opportunity to the minister to do the same. And the minister is arguing that since it's their burden of proof, that they wish to make their statement first and question first. Ms. Manning first. Obviously, Professor Matthews, is not their witness, so she would be questioned by the counsels who called her. Did I adequately summarize the position of the parties at this point?
Yes, I believe so.
Mr. Lashley?
Yes, I'm sorry. It's having a little technical problem. Yes.
Okay, it's not a problem. So that being said, let me just say, Mr. Bloom was saying that he believes that the burden has been reversed and that it's actually the burden of Ms. Manning to demonstrate admissibility. I wouldn't agree with that position, Mr. Bloom. I do believe that in the circumstances as they are, it is the minister's burden to demonstrate that Ms. Manning is inadmissible to Canada. And therefore, I will have the minister present the evidence in the way that they see fit. In this particular case, what I'm understanding is they're making an opening statement and they're questioning Ms. Manning. Afterwards, of course, you can do the same. And when it's time to call Professor Matthews, that since that's your witness, you will be questioning her first. And then the minister will, at that point, question her if they have any further things that they wish to ask. Now, just to be clear here, let me just double check something. I do need to make mention of the fact that apart from the issue of admissibility pursuant to 36(1)(b), counsels for Ms. Manning have raised a constitutional question. Therefore, that is also another element which will be analyzed if, of course, I come to the initial conclusion that Ms. Manning is described at Section 36(1)(b). I will have to look at whether or not the constitutional argument made by counsels is a valid one before I determine the issuance of a deportation order. Just on that note, counsels for the minister, Minister Lashley or Madame Barrette, I did not receive up until now any written response from the minister in regards to the constitutional argument. My assumption is that you'll be addressing that in your written submissions after the proceedings. Is that correct?
Yes, that is correct.
Okay, very well.
Madam Board Member, there is one other issue. I'm sorry.
Yes. Yep.
Didn't know if I should wait until we were at a point where we were going to hear testimony from the witnesses, or if to raise it now. I prefer to raise it now so that it's clear and it's out in the open. It's with regard to the qualification of some of the experts, some of the witnesses as experts. I understand that they've submitted expert reports, but I also understand that normally the procedure is that witnesses have to be qualified by the board as experts before being qualified as an expert witness. And I'm not questioning their expertise at this point because I haven't had a chance we haven't gone through that exercise. Mm-hmm. So I'm just wondering how we're going to address that.
Okay. So let me just let the parties know, I actually have a list of issues that I'd like to address before we actually get into the nitty-gritty, so to speak, of the testimonies and whatnot. That is one of the issues that we will be addressing. So I'm just trying to go through them one by one and make sure that we cover, as I said, there's some technical issues or what I call issues of form that I'd like to address. And there's some more, as I said, legal issues that I'd like to address as well. There are several. So as I said, we won't be getting into the actual oral presentations for a few minutes until all those issues are looked at. But thank you for raising that, Mr. Lashley. The next thing I'd like to quickly look at is the disclosure that has been submitted, because I just want to make sure that everything was actually received by all of the parties. Okay. So for the minister, the board has received exhibits C1 to C19. Is that the totality of the documentary evidence that was submitted by the minister, Mr. Lashley?
Yes. C1 to C19. Thank you. That's correct.
Okay. So in that respect, if you don't mind, I would like to, actually, you know what, we'll get to that later, because there's something about the evidence that I want to clarify, but we'll get to it in a moment. Counsels for Ms. Manning have provided exhibits 1 to 51, and then there's also a video entitled Collateral Damage that they wish to show that they have provided the link to. Is that correct, Mr. Bloom?
That is correct.
Okay. So what I'll do is, for the sake of reference, normally what we do is we give the exhibits for the person concerned the title or the reference of the letter P. Okay, so P is in Papa. So P1 to P52, which is the video, are the exhibits of the of Ms. Manning's counsels.
Mrs. Board Member, the minister will have an issue with the video.
Okay, what's the issue?
We do submit that the video was filed late, and it was not filed in a format that is usually expect. It should have been submitted on a CD and given to the party. I don't believe the transmitting a link is the way to submit a video.
Okay, so the minister is objecting to entering exhibit P52, the video collateral damage, into evidence because of the format in which it was submitted. Is that correct?
And also because it was submitted, I think, 1 or 2 days before the hearing.
Okay, so late disclosure. All right.
Yeah, late disclosure.
Okay.
Furthermore, we don't see the pertinence of the video concerning the equivalency. But it's a totally another issue.
Let me just give the parties, or the councils, excuse me, an opportunity to respond. Just give me a moment, please. Okay, so Mr. Bloom, if you, or I'm not sure who wishes to respond, but if it's you, Mr. Bloom, please go ahead and respond to the objection raised by counsels for the minister in regards to exhibit P52.
I mean, at the outset, could I please ask Minister's Counsel to identify where in the Immigration Division rules there's the requirement to submit a CD in advance?
The way you have to submit physically an evidence. You either submit a document, or I don't believe a link qualify as evidence.
Okay, well, let me just ask a question before we go any further. I just want to be clear. Were Minister's Counsels in a position to view the video? Did you have difficulty viewing the video, or were you able to actually view the content?
We were able to view it.
I viewed the video as well.
Okay. Go ahead, Mr. Bloom.
So, I mean, the video in our submission is not new evidence. It's described at length in the record, and in particular in the affidavit of in the report of Professor Matthews. She describes its contents in great detail, and we are asking her about the video. So we believe it's in everybody's interest to simply view the video that she's talking about rather than have her detailed description of it. We submit that there's no prejudice to any party in simply watching an event that's described in detail in the evidence, and would actually assists in understanding the testimony. In terms of where it goes, we agree that it doesn't go straight to equivalency, but we submit that it goes to the defense of necessity that we are raising if equivalency is found. And we submit that it goes to our constitutional arguments, which say that you can't criminalize a disclosure, a whistleblower's disclosure where the public interest value of what is disclosed outweighs the harm. So it goes to both necessity and to our constitutional arguments. We don't see any basis in the rules or on fairness not to simply view it during Professor Matthews' testimony.
Okay. Did you want to speak? I think you've already referred to it indirectly, but did you want to speak to the late disclosure argument made by the minister?
So in our submission, because in our disclosure that was in accordance with the rules, it's described at length. I don't think the video watching makes it late disclosure. But if it is found that it is, we would ask you to please admit it or let us watch it, because there's been no prejudice to the other party and it's relevant and probative to the issues I've just said.
All right, thank you. Council Gill, did you have anything you wanted to add to the comments of Mr. Bloom? Council Bloom?
None at all, thank you.
Council Lashley, did you have anything you wanted to add in regards to the arguments made by your colleague?
No, I have nothing to add. Thank you.
Okay, thank you. So in regards to the objection raised by the Minister's Counsel to admitting Exhibit P52, the video entitled Collateral Damage, into evidence for today's proceeding, I do not believe there is any valid reason for me to reject this particular exhibit. First and foremost, in regards to the late disclosure argument, yes, technically we were advised not within a 5-day time frame that this video would be, was a request to show this video during the proceeding. However, I do agree with the submissions made by Council Bloom to the effect that this is not evidence of a nature to surprise the parties in the proceeding, given that, as he stated, it is described, the contents are described in detail and at length in the documentary evidence that was provided. So again, it's not really new information. It's just a video format of some of the information, a lot of the information that was presented in writing. In regards to the pertinence of the video, yes, I see that it will be shown in relation to the testimony of Professor Heidi Matthews, and my understanding as well was that she would be speaking mainly to the arguments being made by counsels for Ms. Manning in regards to the defense of necessity. And therefore, I do find that in that regard, it can be considered to be pertinent. So the objection is not found to be well founded. The exhibit will be entered. Excuse me. As for the format, I apologize. I wanted to address that. As for the format, again, the parties, including myself, were all able to view the video. Whether it's in a CD format or otherwise, I don't believe is necessary at this particular time. The important thing is that we had no difficulty in actually viewing it. Modern technology allows us, obviously, to have a link rather than a physical CD. I think we can be flexible enough to consider that this also can be considered an exhibit and entered into evidence. So that closes that particular issue. Was there any other issues with the disclosure or any? I have a couple of things I want to raise, but I'll just let the parties speak first if they have any particular issues they want to raise in regards to the documentary evidence that was disclosed. So, counsels for the minister, any other issues you want to raise? No? Counsels from Ms. Manning, any other issues you'd like to raise?
No, nothing further.
So I have a couple of things I'd like to look at. One of them is really, as I said, I think it's just a question of form, but I think it's important to raise it. So it's for the minister's counsels. I'm looking at the amendment to the admissibility report, so Exhibit C3. I think it's just an error, but I prefer to clarify it before we go deeper into the proceedings. In the replacement text, you have cited that on August 23rd, 2013, and you've cited that there were the charges under Article 134 of the Uniform Code of Military Justice, and you've referred to specifications 2, 3, 5, 7, 9, 10, 11, 13, and 15. In my reading of the evidence, and please correct me if I'm wrong on this, I believe 11 and 13 are do not belong in this particular section. 11, I believe the individual was found Ms. Manning was found not guilty, and 13 belongs in the second section of your report. Can you please clarify? I'm raising this, as I said, only because I just like for this to be clear before we get into it. It doesn't affect the fact that there are other charges that are being raised. It's just these two particular ones don't seem to belong in this section. Are you speaking to us, Mr. Lashley? Because you're on
No, I'm sorry. I've taken off the mute. Yes. So I'm sorry for the delay. Yes, Madam Member, I'm seeing that clearly with reference to specification 11, Mrs. Manning was found not guilty, as you've cited, and with reference to specification 13, it seems that it was it's also written with regard to the allegation of equivalence with with the 342.1 of the Criminal Code of Canada. So I apologize for the error, and thank you for making that clarification.
Okay, well, that being said, does the minister wish to make a motion to strike those two specifications from the amendment? And then, of course, I'll ask counsels for Ms. Manning if they have any objection to that.
Yes, given the circumstances, I would ask that we strike specification 11 and 13 from the amendment that in the first part of the report that refers to because 13 is repeated, obviously. So I would just ask that 11 and 13 be stricken from the amendment in I imagine it's the fourth paragraph of the report.
Counsels for Ms. Manning, do you object to that?
No objection. Thank you.
All right, so in the first section of the replacement text of the amendment to the report, to the inadmissibility report, we will strike specification 11 and 13 from that section as they are not pertinent. All right. The second issue I'd like to raise in regards to the disclosure the minister has provided is more in regards to the legislation, so the sections of the law that the minister has provided into evidence. As we discussed at previous admissibility proceedings, the jurisprudence indicates that we are to look at the offenses at the time that they occurred. Okay? The minister, and this is a little more of a tricky issue here, so I need to understand what each party's position is on this. In regards to the Canadian legislation, obviously I can take judicial notice of this. It doesn't need to be proven to me. I would just like to know from the parties if the parties both agree that we should be looking at the Canadian provisions as they were at the time of the offense, which in this particular case, I believe the offenses occurred in 2010. The conviction, I believe, was later on in 2013. So, Ministers' Councils, can you state your position in regards to that, please? And the reason I'm bringing this up, of course, is because the excerpts that have been provided in the evidence of the Canadian statutes are dated 2021 for Section 16 of the Security of Information Act and 2019 for Section 342.1 of the Canadian Criminal Code. So, Mr. Lashley, what's the minister's position on that, please?
Yes, thank you. I'm seeing that now. As you mentioned, I am in agreement that we should be looking at the Canadian law at the time the offense occurred, which is 2013.
Okay, so let's just clarify that though. The offense versus the conviction. The offenses occurred in 2010 and the conviction occurred in 2013. In this particular case, we just need to look at, was there any change in the legislation? As I said, I can't take judicial notice. I did research what the provisions stated at that time. I believe there was no change for Section 62 of the Security of Information Act since that time to today. However, in the Criminal Code, Section 342.1, there is a slight change in the definition section, i.e. the definition of data existed at the time of the offense. It was repealed in 2014. So, Mr. Bloom, can you or respond to the minister and to my comments in regards to this issue, please?
You raise an interesting issue. I don't think to my knowledge, there isn't settled law on that point. I think if we look at 36(1)(b), all it says is convicted of an offense that, if committed in Canada, would constitute an offense. So would constitute, I read that in the present tense, but I have not turned my mind in detail to this issue, and so I appreciate you bringing that up, but I'd ask to address it more fully in written submissions.
So the reason this issue has been raised more recently, obviously, is because of the Tran decision. The Tran decision wasn't reference, obviously, to Section 36(1)(a) of the Act. However, in terms of the admissibility proceedings before the board since the Tran decision, the minister has taken a position that it also applies to 36(1)(b) as they have today. So that's the reason why this issue is being raised at this time. My concern is the following. We all need to be working with the same legislation. So obviously we can't, it's going to be too late when it comes time to making arguments. We need to actually determine at the outset what legislation are we looking at. I feel this is the key issue, not only for the Canadian legislation, but also for the foreign legislation, which we'll get to in a moment. That is something that needs to be proven. I cannot take judicial notice of foreign legislation. I can only do so for Canadian legislation. So that's why I feel that we need to take a little bit of time to look at this issue now to determine which laws are we looking at from what time. So as I said, I don't think it's an issue for 16.2 because, as I said, there was no change, so it's really a moot point. But for Section 342.1, there was, as I said, a slight difference in, as I said, the definition of data being included at that time and being repealed in 2014. So, Mr. Bloom, as I said, I would prefer to comment in regards to that at this time. If you have anything further to add apart from what you've already stated.
So I think that I would distinguish the foreign offense. I think we're definitely talking about the law at the time of the conviction. You were convicted of a specific offense with specific elements. So I think that would have to be the focus of the equivalency. My position is that 36(1)(b) is looking at the law as it stands at the time of the inadmissibility report. So that is our position on what law we're looking at. I would add that the definition of data is not material to our argument.
Okay. All right. So that being said then, Mr. Bloom, the minister, as I said, it is the minister's burden of proof. The minister, and correct me if I'm wrong, Mr. Lashley, has indicated that they will be working with the definition, the section of the law as it was at the time of the offense, therefore going back to the era of 2010, 2013. So that is what they will be
That's
argued.
we have no we have no objection to that.
So the change
Okay.
may not be material in the end, and it may not impact the arguments in any way. But what I would like the parties to agree on at this time, if you do agree, is that we will be working with the section of paragraph 34.1, excuse me, of the criminal code as it was at the time of the offense. Does everyone agree with this? Mr. Lashley, can you just confirm, please?
Yes, I confirm, and of course we will address all of that in our submissions.
Okay.
But I understand your concern that we all work with the same law.
Okay. And Mr. Bloom, same thing. Would you agree that we'll be working with the law as it was at that time, that particular section as it was at the time?
Yeah, we have no objection to that. Thank you for raising it.
Council Hill, did you want to add something?
Yeah, at the risk of stating the obvious, the only thing I would add is, of course, when we're evaluating the constitutionality of the Canadian provisions, we're evaluating the constitutionality today, and the board doesn't have jurisdiction to apply an unconstitutional law retroactively. So, of course, our submissions on the constitutionality of the offenses is with regard to the Charter and constitutional jurisprudence as it stands.
Thank you. So that was regarding the Canadian provisions. So in regards to the foreign provisions, yes, as the council has stated, and the jurisprudence also speaks to the fact that we again need to look at the time of the offense. The minister has provided provisions for section 793E of Title 18 of the U.S. Code and section 1030A1 of Section 18 of the U.S. Code. Of Title 18 of the U.S. Code, from 2013. Do the parties agree that that is the section? Those are the sections and the time frame that we need to be looking at in the circumstances. There's no issue with that.
Yes, we agree.
Yes, we agree.
All right. So then the only issue for me is that one, I'm not sure why it was provided, but if it is going to be argued, there was another section of law that was provided by the minister. Just a second, please. I'll find it. Foreign law is what I'm referring to here. Exhibit C14, Section 1034 of Title 10 of the U.S. Code is dated or in effect November 2020. So again, I just need a clarification on the minister's position in regards to this because, as I said, foreign law needs to be proven. I cannot consider anything but what the minister has provided into evidence.
If you look at page 137, 138, you can see the amendment with the date.
Okay, so what the minister is saying at this point is that with the excerpt they've provided, we can deduce that there was no amendment to that that would affect this particular section in regards to the time of the offense.
Yes.
Mr. Bloom, would you agree with that?
Yes, we agree.
Okay, very good.
Sorry, my co-counsel.
No, I just want to clarify, we agree that that document indicates the historical amendments to that provision, but we take no position on whether or not those amendments were material or substantive. We would only take the position that the version enforced at the relevant time of the events is the version that should apply, and it's on the Minister's Council to demonstrate, what that legislation says.
Very well. Thank you. Okay, I think that covers the ground in regards to the legislation. Let me just double check, please. Okay. I think that covers those issues. Let me just see about the other things. All right, that's fine for the documentary evidence. Now we'll talk about the expert witness and also the reports that were provided by counsels for Ms. Manning in regards to 3 individuals that they are presenting as experts in their field. Just give me a moment and I'll pull those up. Won't be long. Excuse me, I'm just going to go off camera for one moment because they're actually behind me. Won't be long. Okay, so what I understand, Mr. Bloom, is that the only expert who will be called as a witness is Heidi Matthews, and for the other individuals, you will simply be relying on their reports. Is that correct?
That's correct.
Okay. So, Mr. Lashley, you wanted to, I'm not sure if you were raising an objection to the qualification of these individuals as experts, or if you just wanted to have a confirmation by the panel that they are being qualified as experts. So if you could just clarify your position, please.
Thank you. First, regarding Ms. Matthews, I understand that she is going to testify today, and the minister will have an opportunity to ask questions and to address her qualification as an expert, which I think is common. We may have questions to.
Sorry, you said Ms. Manning. Are you talking about Ms. Manning?
Did I say Ms. Manning? Ms. Matthews.
Unless I misunderstood you, I'm sorry.
Sorry, I thought I said
Professor Matthews.
Professor Matthews, thank you. Sorry about that. So again, Professor Matthews will be testifying today, and we will have an opportunity to ask her questions, to question whether we believe she should be qualified as an expert, and if so, what will be the scope of her expertise. Those are our comments with regard to Professor Matthews. With regard to the other witnesses, we simply note that the reports that were submitted in support of their testimony are qualified as, perhaps it's just a title, but we want to be clear, they're qualified as expert reports. So our question is, we would like an opportunity, obviously, to cross-examine these witnesses. We question whether they are being accepted by the tribunal as expert witnesses, or is it simply an expert report? Is that simply the title? For us, that's unclear.
Okay, well, I'll ask Mr. Bloom to clarify what their intention is with the presentation of these reports. I believe he already indicated in a previous correspondence to the board and to CBSA that they would ask that these individuals be considered as experts, and that if I don't want to speak for you, Mr. Bloom, so I'll let you go ahead and give your reply to the Minister's Council, and then I'll respond to that. Go ahead, please.
No, that's absolutely right. In our cover letter to the evidence, which was from 23 September 2021, we state that we state the expertise. We state that of each expert witness that we have provided evidence from, we state what their expertise is, why they are being called. And most importantly, we say if the minister has questions for these witnesses, please let us know as soon as possible so that this can be arranged. So we have seen from the minister's lack of response that we took that they do not want or have no interest in cross-examining these witnesses. And so I don't believe they can say now, then object to their testimony because they are not here, when we've very explicitly said that we don't have a need to call them. We're relying on what they say in writing, but that if the minister does want to call them, that could absolutely have been arranged. This was on 23 September 2021. What I would add in terms of their expert reports is that each one speaks to their impartiality, speaks to their independence, speaks to that they know the requirements and obligations of an expert witness, and speaks to their qualifications, which for all of the experts you have in writing are quite significant. They've also all been qualified as experts by courts, as you can see by their CV. So we do not see how at this point the minister could object to their qualification as experts. I don't see how they could be suggested that they are partial or biased, nor could it be suggested that they don't have the expertise to help us on the issues. So in my submission, all of the relevant points are set out in writing.
All right, thank you, Mr. Bloom. Council Gill, did you have anything you wanted to add?
Thank you.
Okay. Mr. Larche or Madame Barrette, do you have anything you want to add in reply to Council Bloom's arguments?
Yes, I would like to mention for the board that 10 days before the hearing, the minister received 996 pages of evidence containing 4 reports of expert witness and 3 other reports that it's not clear if they're expert or just other professional. I don't believe the minister has lost his right to ask for a cross-examination because he did not respond in the delay set by the defense. I just would like to, just a second. Technical issue, okay. The minister has the right to cross-examination, and if not, we will argue the probative value of the document. And at this end, I would like to mention the decision of the Supreme Court that has already ruled that the absence of cross-examination significantly reduced the probative value of an affidavit. Without cross-examination, the court cannot attribute much or any weight to such evidence because it is impossible to assess its probative value and prejudicial effect as the legislation requires. As of the qualification, I do believe from the jurisprudence it's clear if you want to call an expert witness, you have to qualify before the board. The board has to decide what his qualification is, and it's not in his report that the expert decide himself what is the expertise going to be in front of the board. So yes.
Could I add a brief response?
Yes, go ahead.
So our letter is from 23rd of September, so 2 weeks ago, and it is very explicit what we are presenting their expertise as. It says in bold, if the minister wishes to question these witnesses, please let us know as soon as possible so that this can be arranged. The qualification is for the board to make, and we are arguing, and we'll argue in written submissions, that they are qualified, but we don't need to run every witness here when we are relying on what they have to say in writing and aren't asking to just repeat it overall in person. This isn't a court where we have an examination in chief on each point. This is a tribunal, and we have their evidence in writing. So the minister had every opportunity to cross-examine. I don't think the 23rd September letter could be more clear. Thank you.
The only thing I would add is, despite the comment that the volumes were totaling over 1,000 pages, the vast majority of those documents were in fact matters of public record. The expert reports themselves total no more than about 130 odd pages. And there was ample time to review those documents and decide whether or not it would be necessary for Minister's Council to examine those individuals.
Okay. There's nothing further, then I'll give my response to this issue. Okay, so in regards to the qualification of the individuals being presented as experts, one of the individuals, as I mentioned, will be called as a witness. The other 3 have provided detailed reports, which I believe all of them include a CV of their work, detailing their fields of expertise. First and foremost, in regards to the ministers, the issues that they have raised, the issue of volume of disclosure, precluding them from dealing with the issue of the experts being referred to in the disclosure, for me, is not pertinent. These particular reports were provided in a timely manner. They were provided with sufficient time for the minister to determine whether or not it was necessary for them to call these individuals as actual witnesses during the proceedings. Counsels for Ms. Manning did offer this opportunity to the minister. They indicated that they would make the proper arrangements if the minister wished to have any of the other individuals brought forward as experts to testify during the proceedings, and the minister did not provide any response to that offer made by counsels for Ms. Manning. So they did have an opportunity to be able to question these individuals if they felt that was necessary for them to be able to speak to their expertise in their respective fields. That being said, I also think that in the circumstances, I don't necessarily have to qualify them as experts immediately at the outset of the proceedings. In regards to Professor Heidi Matthews, we will be, not only do I have her report, but we will be hearing her testimony. As we have done in previous admissibility proceedings, there are cases where either an individual, after they testify, for whatever reason, the panel may come to a conclusion that they are not actually an expert in the field that is being presented for these particular proceedings. Even if I do qualify someone as an expert at the end of hearing their testimony or from their report, it could also be that after having analyzed the situation as a whole and the report as a whole, that their testimony is their evidence is more or less pertinent to the proceedings. Finally, I can also come to the conclusion, based on their report and their CVs, that they are actually not experts, but rather ordinary witnesses, and give their information or their report the weight that we would give to an ordinary witness. All of this to say that I am going to ask that we reserve this particular qualification for now, that the parties will be able to speak to the nature of these reports and whether or not the information contained should be considered as coming from an individual with considered an expert in their field for their written submissions. And I will obviously speak to that in more detail when it comes time to make a final determination in this matter. So I will be obviously allowing the reports. The reports are already allowed into evidence, so that's not in question. As for the qualification, that will be reserved for the final decision, and the parties will make their written submissions to that effect. If the minister feels that for whatever reason any of these individuals should not be qualified as an expert, they will have to do so based on the written reports, given that, as I said, they have not indicated in advance their desire to have them testify in person. So that deals with that particular issue. I think, just a second, I think someone else is trying to get in here. Just a moment, please. No, I think we're good. I think that covers the issues the preliminary issues that I had on my list. Let me just double check. Yes. Council Bloom, you had mentioned in one of your correspondence, and you had provided into evidence a non-disclosure agreement relating to your client, to Ms. Manning, and you had indicated that there were certain areas which she might not be able to testify to. Can you just give a little bit more clarification before we actually get into the testimony, so that we can understand what the what the impact is of this non-disclosure agreement on this particular proceeding today?
Sure. I think my co-counsel is actually best placed to speak to that.
Please go ahead.
Thank you. So that non-disclosure agreement is at tab 48 in volume 3 of the materials. It's an agreement between Ms. Manning and the U.S. government. It is still in effect today. She's still bound by this agreement. This agreement covers, it's very broad. It bars her from speaking to any of the documents. In particular, as it relates to this proceeding, it bars her from speaking about the specifics of the information in any of the documents that she revealed. And so we would object to any questions about the content of the information that she disclosed on the basis that it would expose her to direct criminal jeopardy as well as civil liability. I would say that Ms. Manning can testify about the relevant acts that led up to her disclosures. She can testify to other elements that she's aware of, under reserve of other potential objections. And we would note that the relevant information is extensively described in the exhibits that we've provided, including her own testimony from her trial, which is at tab 9, volume 1, as well as in the appeal documents filed by our colleagues. The only other thing I would add is that because, of course, we believe as counsel for Ms. Manning that the content of the information that she disclosed is relevant to the proceeding, we've made sure to have an expert available today, which is Professor Matthews, who is qualified and able to speak to the content of those disclosures to the extent that they relate to the necessity defense, the public interest value of those records, and the constitutional question. And so we would say that Ms. Manning is not capable and is bound by that NDA and not able to answer questions in relation to that would lead her directly or indirectly to violate those obligations.
Okay, so basically, just to summarize, make sure I understood correctly, it's specifically regarding the content of the information that was disclosed. It's not regarding any of the acts surrounding the disclosure.
Yes, and because the nature of the NDA is quite broad, Ms. Manning or us, we will object if we start to get into lines of questioning that start to engage those countervailing allegations. But I think, yes, broadly speaking, you're absolutely correct.
Does the minister have anything to add or say in regards to this particular point?
Yes, it's very difficult to pronounce ourselves because we may have questions that we would need answer. And I'm wondering if it would be better if Mrs. Manning would testify on reclos in private.
I'm not sure if that would meet the requirements of the non-disclosure agreement. I think she would still be in breach even if this was considered private proceeding. Please correct me if I'm wrong, Counsel Gill.
Yeah, absolutely. Reclos doesn't change closed session. Doesn't change the fact that by speaking to the content of those materials, she would be in breach of her obligations and be exposed to criminal liability.
Can I make a suggestion? And I'm wondering, again, maybe while we're actually in the testimony, we can adjust, but would it be possible if there is a question in regards to the content, instead of Ms. Manning replying, if counsels can point us to some of the documentary evidence that speaks to that? In view of her actually responding, you can direct us to the documentary evidence that speaks to that particular question. Would that be a reasonable way of proceeding?
Yes, it's very difficult.
Ask if the councils agree, and then I'll come back to you, Madame Ahmed Barret. Don't worry. Just Meg Bloom and Meg Gill, I see you nodding your heads. Just for the record, if you could just respond. Yes.
Yes. Yeah, we do believe that would be a reasonable way to proceed. Of course, there are certain questions at issue in this proceeding that, require proving a negative. And so to the extent that the record does permit us to point to relevant information, we will do so, absolutely. And we believe that's a reasonable way to move forward.
Okay. Oh, I'm sorry, Mr. Bloom, I apologize.
No, thank you. If I could just add, as you mentioned, in the pure equivalency question, what matters is what happened at trial. So we have her testimony on all the relevant documents from her trial in the evidence. Her testimony is for necessity and the constitutional challenge, and we don't believe that requires her to give evidence on the specific content.
Thank you. So now, Ms. Barrett, I'll turn to you. You had something you wanted to say. Go ahead, please.
Yeah, I just want to say it's difficult for the minister to take position on that issue at this time because we don't have enough information. But I just want to remind the board that the minister has the burden of the proof and has to be able to establish certain element of the equivalency. So we'll see if this work or not.
Yes, as I said, we may have to adjust as the testimony goes on, but obviously we all need to be mindful of the fact that we cannot, in this proceeding, have an individual go against an order made by another agency or another court. So it's very important that we be respectful and mindful of that. But I do understand that we do have to get to the bottom of certain questions, and we'll do our best to do that with the information that we have available to us. I think that was the end of my list. So, counsel for the minister, are there any other preliminary issues that you wish to raise before we begin with the presentation, your presentations and then the presentations of the evidence?
I'm sorry. I hear a clicking sound. Is that?
I'm not sure.
Typing. I'm sorry.
Yeah, someone's typing. I think
It's okay.
One of the observers isn't on mute. If all the observers, please, if you can make sure you're muting yourselves, would be much appreciated. Thank you. Sorry, Meg Lashley, you can go ahead. Did you have something any other preliminary issues you wanted to raise?
One last issue. I simply wish to mention that, and you mentioned this at the outset. Prior to the proceedings, the minister made an application questioning the division's jurisdiction to hold this type of hearing for persons who are outside of Canada. And of course, we acknowledge we received the decision and our application was dismissed. We're here today. We're ready to proceed. And we wish only to state for the record that our position on this matter has not changed. But of course, we respect the immigration division's decision, interlocutory decision that the hearing will proceed today, and we're here and ready to proceed. I just wished I had to mention that statement. Thank you.
Okay, very well. Well, there are recourses available if ever that decision, the minister decides to challenge that particular decision. But obviously, nothing was done prior to today, so we will be proceeding in this matter. Sorry, there is one more thing that I'd like to briefly discuss, but it is important because it's already 10:10. So we do need to talk a little bit about timing and how we're going to break down the day, because obviously we need to be realistic about how long the proceeding might take, and we need to have breaks for everyone to be able to refresh, to be able to have lunch. I'm not sure if we'll be able to conclude the testimony of both witnesses by the end of the day today. I could be wrong. I'm wondering, first and foremost, we do have 2 days reserved for this proceeding. If it's necessary to continue into tomorrow, I'm assuming everyone here is available, but is your witness, Professor Matthews, available if for whatever reason we cannot conclude her testimony today? Mr. Bloom or Ms. Gill, if you want to respond to that.
I believe she is. I would just have to confirm her specific times tomorrow.
Very well. Okay. So as I was saying, I do want to take some breaks and take a lunch break because obviously we have to be realistic about how much information we can absorb in one day. I think going up until about 4:30 is realistic. I think after that point, as I said, everyone will probably need to conclude for the day, but we'll adjust accordingly depending on where we're at in the proceeding. Okay. As I said, it's already almost 10:15. My intention, usually when we have a full day proceeding, I usually take a little break around 10:30, and then we take a little break for lunch. What I'm going to suggest, depending on how long your opening statements are, is do you want to do your opening statements, then we break and come back to begin the testimony of Ms. Manning, or proceed differently? I'm open to your suggestions. I'll start with the minister because, as I said, it's their burden of proof and they will be leading evidence in this matter. So I would like to get your suggestions on that so we can know how to break up the day appropriately. Mr. Lashley or Madame Barrette, if you have any comments on that, please.
I'll say that I'm also very flexible in how we proceed in terms of the timeline. Whether Ms. Manning or Mr. Bloom or Ms. Gill would like to take a break now or before the opening statements, for me, it doesn't make a whole world of difference. I don't have a long opening statement, but again, so because it doesn't make so much of a difference for us, I should say, Barrette or myself, I'll defer that to the tribunal and my colleagues. Thank you.
Meg Bloom, Meg Gill, do you have any comments on that? On how to break up the day? Meg Bloom, you're on mute.
Still haven't learned this. We might suggest a short break now, even about 10 minutes, and then we can do the statements and straight into Ms. Manning's testimony.
That's fine with me. Just check here. I don't know if I asked you, Meg Bloom and Meg Gill, did you have any other preliminary issues? I'm not sure if I asked you. Did you have anything else you wanted to discuss, preliminary issues, before we get into the statements?
No, I think that anything else we might have to raise will be in relation to the questions posed by Minister's Counsel.
Okay, very well. All right, so let's take a short break now then, since we've gotten all the preliminary issues out of the way. It's 10:14. Let's say we come back. I'll suggest we come back at 10:30, and then we'll push the lunch break to a little bit later if necessary, maybe around 12:30 or so. Okay. So just one thing I'd like to mention. I will not stop the recording during the break. I will only stop the recording at lunch. So please ensure that you are muted, because if you're speaking during the break, it will be recorded and it will be part of the record. Okay? So you can just mute yourselves and turn off your cameras, and then we'll come back at 10:30. Thank you.
Thank you.
Yes, thank you. So,
Okay. So hello again, everyone. I think we're missing Council Gill. Ah, there she is. Perfect. All right. So as we decided prior to the break, the Minister's Council will now go ahead and make their opening statement. So is it Mr. Lashley that will be making the statement?
Yes, I'll make the opening statement. Thank you.
Please go ahead. Thank you.
So thank you and good morning to everyone. We're here today because we believe that the person concerned, Chelsea Elizabeth Manning, is inadmissible to enter Canada. In our opinion, there are reasonable grounds to believe that she is a foreign national who was previously convicted in the United States for serious criminal offenses, and that if these similar offenses were committed in Canada, they would constitute offenses under an act of parliament punishable by a maximum term of imprisonment of at least 10 years. Over the course of the next few days, we will rely, well, I should say today and tomorrow, we will rely on several elements, including documentary evidence, testimony, an appellate court decision from the United States, Canadian and foreign legislation, to name a few, to establish that there is an equivalency between the offenses for which Ms. Manning was convicted in the United States and our very own Canadian laws. Ultimately, we believe that this tribunal will find that our arguments will be compelling. The information that we will present will be credible and pertinent. And to this end, we believe that the tribunal will issue Ms. Manning a removal order and conclude that she is inadmissible to enter Canada. That concludes our opening statements. Thank you.
Thank you very much, Mate Lashley. Mate Blue, did you wish to make your opening statement at this time?
Thank you. So we're sharing on our screen our outline of arguments. And if you can have that before you, that is best. I will say that I had planned to go into what we are arguing in slightly more detail. If it's all right with the panel, I intend to speak for about 10 minutes.
Yes, you can go ahead, Mr. Bloom, and present your statement as you wish. It's not a problem.
Thank you.
I'll confess that I like to have it on paper, so give me a second. I have it with, won't be long. Here it is. Okay, wonderful. Go ahead, please.
Okay, thank you. So I will begin by apologizing to the panel for our somewhat large record in this case. It's a bit of an exceptional case, and it's one that necessarily raises issues around the rights of whistleblowers and whether the public interest in uncovering the crimes of the U.S. war on terror justified Ms. Manning's 2010 disclosures. In addition, our view is that the interpretations of Canadian law taken by the minister here are themselves quite alarming and required raising constitutional issues. Our position, however, is that you can and should decide this case without wading into any of these issues. We believe that what Chelsea Manning did was justified. However, to decide this case, you do not have to. As you know, the narrow first question here is whether what the respondent was convicted of in the U.S. is equivalent to a serious crime in Canada. And here, we intend to argue that the Canadian offenses proposed by the minister are fundamentally different from what she was convicted of in the United States. On this basis alone, Ms. Manning is not inadmissible to Canada. The case can be decided purely on the differences between Canadian and American law. Now, Canadian law does have a potentially more similar offense to what the respondent was convicted of, but it is not an offense that the minister could have put forward here. It's Section 14 of the Security of Information Act, which criminalizes the release of operational information, broadly defined. However, that law also comes with a built-in whistleblower defense. It shields from prosecution those who leak classified information where the public interest outweighs the harm. In contrast, the United States famously has no national security whistleblower defense. Ms. Manning had no opportunity to rely on the public interest in the abuses she revealed in order to defend herself in her U.S. military trial. And it's well established that for Section 36(1)B of the IRPA, where Canadian law has a defense that the foreign law in question does not, the offenses cannot be equivalent. The leading authority for that is the Federal Court of Appeals 1996 decision in Lee, L.I. So we have a public interest defense for what Manning was convicted of. The U.S. doesn't. The most analogous Canadian offense, therefore, isn't equivalent. We think this case should have ended there. Instead, since September 2017, the minister has spent nearly 4 years scouring Canadian law for some other offense they could argue is equivalent. And they haven't found one. The two provisions that they propose and raise here, Section 16.2 of the Security of Information Act and Section 342.1 of the Criminal Code, are being stretched beyond recognition in their application to this case. So much so that if you accept the minister's interpretation that they do apply, we believe that you would be obligated to then find these laws unconstitutional. I will get to that in a moment. So, turning to our outline of argument that's on the screen and before you, the differences in the essential elements of each offense are set out in Section 1A with reference to our two expert witnesses on American law, Jamil Jaffer and Joshua Drattel. We have also filed an expert report from Professor David Kay on what international law requires before an act of whistleblowing is criminalized. As you can see from their CVs, these are extremely experienced and qualified experts. The minister has not filed competing expert evidence. If they disagreed with our facts or saw things differently, they had every opportunity to file expert evidence of their own. They chose not to. And so, as the offenses are different in their essential elements, according to the test from the Federal Court of Appeal in Hill, these offenses could only be equivalent if the Canadian elements were proven in the respondent's criminal proceedings. Now, we're not talking about U.S. government statements in the press immediately in 2010 after she was arrested. Many of these show that the same U.S. officials later admitted that what they had said was misinformed and overstated. That's in our record. Rather, the elements are not established by media reports, but must be established by evidence at trial. In Section B, you have our arguments to demonstrate that this simply was not the case. Elements like whether harm resulted from the disclosures were explicitly held to be irrelevant by the trial judge. They were excluded when Ms. Manning's defense tried to produce the U.S. government's own assessment that there was no real damage from the leaks. Similarly, issues like whether the acts were fraudulent, a requirement for Section 342.1, were simply not before the trial judge. The judge explicitly excluded any evidence on her good faith motive for the disclosures as irrelevant to the American laws, and they are. So all this to say, while one may not agree with what the respondent did, it is simply a matter of fact proven by the record that there was no suggestion that her disclosures for public dissemination and no material benefit were found an act of fraud. Finally, it was never suggested at trial that Wikileaks in 2010, at the time of the disclosures, was a terrorist group. We eagerly await the minister's theory of how this element of the communication to a state or terrorist group offense can be met. Given the evidence that Wikileaks in 2010 was engaged in news gathering for public dissemination, the charter implications of this position, that the position the government is taking on the meaning of a terrorist group in Canadian law, are quite shocking. Therefore, on the record before you, we are going to argue that the test for equivalency simply cannot be met. This conclusion requires nothing more than observing the differences in Canadian and US law and seeing that as a result, evidence on the necessary elements for the Canadian offenses were simply not before the court in the respondent's US criminal proceedings. This can and should be the end of the analysis. If you agree with us on what I've said so far, there will be no need to look at any of our other arguments. However, if you disagree and find equivalency on either offense, we will argue that an admissibility should not follow because the respondent's actions were justified by the defense of necessity. This is a more difficult question, and if it must be answered, this will require judgment on the justification for what Ms. Manning did. The testimony that you hear orally from Ms. Manning and from Professor Heidi Matthews will go to the defense of necessity. Our written evidence related to necessity is at Part C of the outline of argument. We will argue that the ongoing and unreported killings of Iraqi and Afghan civilians necessitated this act of whistleblowing. We will argue that alternative recourses were not available and in any event did not need to be sought given the international crimes at issue. And finally, that the public interest in revealing these abuses far outweighed any harm. Professor Matthews will testify about the serious violations of international law revealed by the disclosures. The respondent leaked purely historical records on issues of immense public concern, and no concrete evidence of harm has ever been put forward. We are going to argue that the test for necessity is met. Again, if you agree with this submission, this is the end of the analysis. However, it would not be inadmissible. However, if you find the provisions equivalent and a necessity defense isn't available, at that point we have to address the charter challenge that we filed back in August in our notice. I say this because the minister's interpretation of these offenses here, what they are putting forward in a government tribunal as the position of the government of Canada, are completely novel and quite alarming in the legitimate conduct they would criminalize if accepted. If the tribunal agrees with the minister that these are equivalent, accepts this interpretation of the elements, we submit that you must find these laws unconstitutional. We've set out our charter arguments at length, well in advance of the hearing, and I won't go into them in depth here. I highlight only our submission that on Section 16.2 of the Security of Information Act, the minister's interpretation draws no distinction between journalists and terrorist groups. It raises a potential sentence of life imprisonment for legitimate news gathering activity. On Section 342.1, the minister's interpretation would transform contractual breaches, like employer policies, terms of use documents, into violations of criminal law. If the term fraudulent has no meaning other than unauthorized use, then using social media on a work computer in an office where it's not permitted would also fall under the scope of this offense. We further add that acts of whistleblowing are acts of honesty, not fraudulence. They were never intended by Parliament to be caught by this provision. It would be overbroad and chill legitimate journalism and research as described in the affidavit of Professor Ron Diebert. I note since it did come up, Professor Diebert's affidavit is a fact affidavit. He is not being put forward as an expert evidence. He's speaking to information within his own experience, and that's why we have not provided his CV. For the reasons I've just set out and that we will set out in much more detail in writing, the provisions violate Sections 2 and 7 of the Canadian Charter of Rights and Freedoms. As the IRB cannot apply an unconstitutional law, the respondent isn't inadmissible. Finally, our last point, and if you disagree with the above, you find the offenses are equivalent, you find necessity isn't met, and you find the provisions to be constitutional, we submit you must address one final argument. And that's whether inadmissibility should not be applied here because the proceeding has been tainted by an abusive process. The abusive process, we argue, is not delay, as it often is when this is argued, but rather conduct by CBSA that offends the integrity of the process such that it shouldn't be rewarded with a favorable decision. As the documents at Section E of our outline show, The CBSA in official documents and correspondence from various levels since September 2017 repeatedly lied about having referred this case to your tribunal for a hearing. Instead, the file was unlawfully held by CBSA for 3.5 years and only finally referred for a hearing after the respondent threatened mandamus earlier this year. The unlawful failure to refer made it impossible for these years for the respondent to challenge an inadmissibility report that we submit is unfounded. Abuse of process arguments have been granted where government officials are shown to have been repeatedly dishonest in their conduct of a proceeding. Those are the 4 issues that we raise. We submit that only the first argument needs to be dealt with, and that you should find that the offenses are not equivalent if you do nothing further is required. We have a full record that shows on the merits there's no equivalent of offense. The 3 arguments in the alternative, on 1, necessity, 2, the charter, and 3, abuse of process, do not need to be determined if you agree. But we submit that each of these arguments are well supported in the evidence and must lead to a finding that the respondent is not inadmissible to Canada under Section 36(1)(b) of the IRPA. Thank you, and I am happy to address any questions at this time.
Thank you very much, Councillor Bloom, for your comments. Don't believe there are any questions at this time, so if the parties agree, we'll begin with the presentation of evidence. Mr. Lashley, I'm not sure if you're going to be leading the evidence for the minister, but if you are, is it your intention to call Ms. Manning as a witness at this time?
Yes, it is. I'll be the one beginning with questions. Thank you.
Oh, very well. Just give me a moment here to get myself organized. Take notes, won't be long. All right, so Ms. Manning, if you can please unmute your microphone at this time. You are being called as a witness by the minister, so I will place you under oath. Do you solemnly declare to tell the truth, the whole truth, and nothing but the truth?
I do. I so
All
do
right.
swear.
Thank you very much. So just a couple of things. First and foremost, if at any point in time the sound quality becomes distorted or you're not able to actually hear a question properly, please say so. If you didn't
Yes, ma'am.
understand the question or you need it to be rephrased, please say so as well. Okay?
Yes, ma'am.
The other thing I wanted to make mention of, as the parties have already referred to, there is quite a bit of documentary evidence that's been submitted in regards to this proceeding. If the councils are going to be making reference to any of the documents during their questions, I would ask that they please be as specific as possible so that we can all find the appropriate page and excerpt that they're referring to, i.e. by naming the exhibit and also the page number if possible. So, give me a second. Okay, so Mr. Lashley, whenever you're ready, you can go ahead and proceed with your questions. Thank you.
Just, yep, water. Thank you. I'm sorry for that. Good morning. So can you please, for the purposes of the recording, can you please state your full name?
My full name is Chelsea Elizabeth Manning.
And Mrs. Manning, what is your date of birth?
My date of birth is December 17th, 1987.
And are you a citizen of the United States of America?
I am a citizen of the United States of America and of the United Kingdom.
And are you a Canadian citizen?
I am not.
Are you a permanent resident of Canada?
I am not a permanent resident of Canada now.
Okay. Are you a registered Indian?
I am not.
Thank you. I would like to begin by asking you some questions regarding your employment with the United States military.
Yes, sir.
What was your official title with the U.S. military?
My official title with the U.S. military was that I was an intelligence analyst.
Okay. And how long were you employed by the United States military?
I was actively doing my job for approximately 3.5 years before confinement, which is a sort of mixed. You are under the jurisdiction of the U.S. military and technically still under the employ, but not performing any role or job until I was released from prison in 2017.
Okay. And without going into detail, I understand there are restrictions to what you can answer. What were your general duties as a military intelligence officer?
So working in the military, the general duties that I performed were to collect take information that's collected from different intelligence services or intelligence assets and present them to the commanding officer or the staff officers for whichever level of either battalion, brigade, whichever level I was at. I was at the brigade level, so I was I worked as an S2 fusion cell analyst for a year and a half at 2nd Brigade Combat Team, 10th Mountain Division, Fort Drum, New York.
Okay. And to do that particular job, did you receive any specific training?
Yes. So I received approximately 10 weeks of basic combat training at Fort Huachuca in Fort Leonard Wood, Missouri, and then I went to Fort Huachuca in Arizona and received more specific training at for working more in the intelligence analyst role, and then there's continuous on the job training going down to going to different places and going and traveling to different schools and continuing. There's a continuous education, but the initial entry was approximately 4 to 6 months. I don't recall the exact number of weeks.
Okay. I want to refer to a document that we filed, which is document C7. It is entitled United States Army Court of Criminal Appeals. And I'm, just to be clear, I'm on page 2, which is essentially which is the second page of the document, providing a background information as presented by Senior Judge Campanella. Is everyone on that page?
Yeah, thank you. Yeah,
you
take just a second to make sure.
Oh, yes, of course. Yeah, I'm not too familiar with the share screen, so I prefer just the one. Yeah.
Okay, please go ahead.
Okay, so I'm on page 2, and on page 2, about mid-page or 3/4 down the page, it begins a paragraph entitled Background. I just want to read a line from what is written in this background, and then I'd like to ask a question following reading what's written on the page.
Sure.
Okay, so under background it says, and I'm in that paragraph on the second line. It says, referring to Ms. Manning, Army Intelligence Analyst, Advanced Skill Training. I'm sorry. Yes. Attended and passed the Army Intelligence Analyst Advanced Skill Training, which included lessons on terrorist use of information on the Internet and lessons on information security.
Yes, sir.
Now, okay, so my question is, what does that? I don't know if you're at liberty to answer. What does that entail specifically?
Sure. Those would probably be if this is referring to the time period that I can recall. This would be about 3 hour. These would be about 3 hour modules inside a larger program, the initial entry program. So this would be about between this would be a moment of instruction, probably a PowerPoint presentation with an instructor for approximately 3 hours each, basically the time period between breakfast and lunch, or between lunch and dinner, during training, so a classroom training environment.
Okay, and regarding the lessons of terrorist use of information on the internet, was that part of the instruction that you received? Can you confirm that?
Almost certainly, yeah.
As well as lessons on information security. Can you confirm that as well?
Information security would be more than one module. I think that would be multiple days of instruction for information security. That's a much more comprehensive course of instruction, as far as I recall.
Okay. As I continue along in this document C7, and I'm now on the page 3. In the second paragraph, is everyone still with me? It mentions, in speaking of Miss Manning, appellant, being Miss Manning, was taught how to use numerous information sources to conduct intelligence analysis and create intelligence reports. So is that accurate? Were you conducting an intelligence analysis and creating intelligence reports?
Yes. So I was producing intelligence reports and also creating products, which is slightly different than an intelligence report, but it's very similar. It's like death by PowerPoint version of a report, and then there were presentations along with that. So about a third of my job was reports, and another 2/3 of my job were death by PowerPoint in preparation for death by PowerPoint. So.
Okay. And were these reports classified? The reports that you were producing?
Sometimes domestic reports that were made within the United States while we were not deployed did not always have classified information. Sometimes they would just be sensitive information, or sometimes it would be as simple as just going over daily or weekly weather reports and like the news for that week, whatever the commander requested, or that my superior intelligence officer deemed relevant for that week. Now then, in theater or in preparation to go to theater, or for more sensitive matters that were happening domestically, it would almost certainly involve classified information. Typically at a mid level, but not the highest level. But and then in the U.S. it would be or not in the U.S. but overseas it would be at a much higher level.
Just so I'm clear, based on your experience as an intelligence officer, what is
yes, sir?
What is the distinction? You made an important distinction. What is the distinction between classified and sensitive?
The distinction between classified and sensitive, classified information meets certain criteria set by the executive branch of the United States. So it sounds quite vague and quite broad, but it is information of and relating to the national defense or foreign relations. And specifically for the different tiers and grades, it is information that could harm national security being of and relating to the national defense and foreign relations, whether it would cause serious harm or cause grave harm is, I think, I think that those are the tiers. Like, so regular harm would be confidential, serious harm would be secret, and grave harm would be top secret. Those are there's no breakdown in terms of that. Those are discretionary by different officers or original classification authorities within the U.S. government.
Yeah, I'll just step in here to say, of course, no objection with Ms. Manning explaining her understanding of the classification framework in the United States, but of course she is not able to testify to U.S. law.
Thank you. So,
Just so clear, Mr. Lashley, I apologize. I did hear you ask the question as to your understanding. So I agree with your interjection, Counsel Gill, but we do all agree that this is Ms. Manning's understanding of the classification system. Thank you.
Thank you. So, based on your understanding, again, this distinction is based on what could potentially be harmful or could potentially be more harmful, or is that?
Not my distinction. That is the distinction of the executive branch, specifically the president and designees to the department heads, and then the deputies of those heads. They are the only classification authority that really matters in terms of like how the U.S. classification system works is the president of the United States. But various heads and officers of the agencies set criteria, and those are what get used to determine what is and is not classified. So it's very it can be. I mean, and original classification authorities often disagree quite regularly as to what is and is not classified at any given time, and what one agency determines is classified and not. So there is a little bit of confusion and leeway, but that's usually resolved.
Okay. So my understanding is you were working with classified documents. Is that correct?
Correct. Yes, I was.
Were you yourself ever called upon to render information classified or to designate it classified or sensitive?
So we were every single intelligence official working with classified information that has to produce it is what is called a derivative classification authority. So what we do is we take criteria that is written by an original classification authority, and we apply based on this criteria, which is usually a 30-page document, as to what is and is not classified. But we just put classified by in the corner of the document and the date, and that is not necessarily. I mean, it is assumed to be classified at the time, but it is not. It doesn't have the same. It doesn't have the same weight in terms of like it is. It is 100% classified until an original classification authority signs off on it, which is quite rare. But I mean, we assume all derivatively classified documents are classified at the time of their production and are treated as such until somebody with a higher authority deems that it's not.
Okay, thank you. Were you at any time asked or required to sign non-disclosure agreements?
Yes, I have signed so many non-disclosure agreements in my time in the military that I don't recall how many it was, but at least 3 or 4. There were at least 3 or 4 times that I can recall where it was sitting in a room and I had to sign a document.
Do you recall what the nature of these non-disclosure document was? Like what were the restrictions?
Yes. So
to your recollection. Oh,
sorry, can you just clarify the relevant time period you're referring to here?
I'm sorry.
Thank you.
I'll be more specific. I'm sorry, Ms. Manning. I'm sorry, Ms. Gill. So again, I'm referring to the same document, which is C7. I'm on page 3 and the 3rd paragraph, and I'm making reference to the 3rd line of paragraph 3. It mentions on April 7th of 2008 and 17 September 2008. Appellant signed 2 separate non-disclosure agreements acknowledging she understood the security indoctrination concerning the nature and protection of classified information. That's the line I'm referring to. So I wanted to confirm with Ms. Manning, in fact, that it's her recollection of having signed those 2, to be specific, those 2 non-disclosure agreements. So is that accurate? And I'll allow you just to answer.
Yes, those are the first 2 that I signed, as far as I'm aware. Yes.
Okay. And again, in the same paragraph, in the following line, it mentions that the appellant, being you, avowed not to divulge classified information to those not authorized access and acknowledged doing so would be a criminal act. You say you remember signing non-disclosure documents. Is that an accurate statement?
Yes, sir, it is.
Okay, thank you. In the following paragraph of the same document, it mentions, and I'll refer to the specific line, it mentions that I'm on the second line. On June 13th of 2008, appellant, again being Ms. Manning, created a slideshow entitled Operation Security. Ms. Manning, do you recall creating a slideshow in 2008 entitled Operation Security?
Yes, I do.
Okay. What was the nature of this slideshow?
So I posted a video on YouTube from my barracks. I was prior to being in the Army. I was a vlogger. I was a video blogger. I posted videos regularly on YouTube. I posted one from the barracks, and I was told at some point that either the staff at Fort Huachuca during my training in Arizona brought this up, or somebody brought it up to them, and I was pulled aside, and I was told that I should take this video down, and that it could contain sensitive information, and could be they basically just didn't want me to post YouTube videos while I was on the military base anymore and say who I am and what my job is. So I was, as punishment, I was required to produce this slide, or produce the slideshow and present it to all of the other trainees during I think an afternoon briefing at the end of the week as punishment. I produced the slides, but there was it ended up being I used on index cards in the end, so I had to copy all of the things that I put down in there and put it into index cards. And so I gave a briefing on this in that time frame, like June 2008.
Okay, thank you. Okay, sorry for the delay. I'd like to speak now about some of the information, or the information that you had access to, and I'll be very careful not to. I submit, Gil and Plum, not to try and go to detail. I'm more interested in your access to the information. So I'll just as a lead in, I'll begin with my question. Ms. Manning, is it safe to say that you had access to classified and sensitive information relating to the U.S. military?
Yes, and other government agencies as well. Yes.
Thank you. On page 3 of the Court of Appeal document, as I scroll down to the 5th paragraph, I am on the 4th line, and it mentions that the appellant had access to and reviewed voluminous amounts of classified and sensitive. I'm sorry, I should mention we're in the context of 11th of October 2009, and it mentions that the appellant had access to and reviewed voluminous amounts of classified and sensitive information across the intelligence spectrum. This included SIGACTs in both Afghanistan and Iraq, as well as, so we'll begin with that. Do you confirm that this is accurate, that you had access and reviewed voluminous amounts of classified information with reference to SIGACTs?
SIGACTs, I mean, they were certainly, that was how we pronounced it, was SIGACTs. So those documents, while they're not necessarily intelligence documents, they are typically classified documents that I routinely had access to and went over.
What is a SIGACT? If you don't, Could you explain what that is?
So it's any event that occurs within a theater of operations in the U.S. military. Essentially, what happens with the production of a significant activity is that a soldier out in the field or their sergeant will report an incident or an event, and so they will put in they will put together a report. They go into what is known. The way it was dealt with whenever I was in the military was that they would go to their Blue Force tracker, which was a computer system, and they would type in the different bits of information like the time, the place, the grid coordinates of whatever event it was, whether it was there was certain criteria as to what it was, whether it was an IED attack or some suspicious activity, an accident, a friendly fire incident. So there was something like 50 or 60 different types of activities that could be reported in these things. And so these kinds of things, there were a number of fields that were associated with these documents, and so they would go down the list and return these things into field. Return these things, send them over classified network through the Blue Force tracker, which would then go to a more central headquarters and then be approved by a battalion officer, and then submitted higher up to the brigade, and then put at the division level into a broad global database that was held by the Corps. So that's how a SIGACT is born.
Okay. Thank you for the explanation. It also, as I can continue in this paragraph, it makes reference to the U.S. Southern Command Southcom detainee intelligence reports and U.S. State Department diplomatic cables.
Yes.
Now, is Southcom essentially the same thing but refers to a different area, or is there? Can you explain what Southcom is, please?
So Southcom is the southern hemisphere of the United States. Actually, it's really anything south of the Mexican border, and Southcom is basically the highest level of general officer in the military, joint general officer, so a 4-star general of any branch of service. Runs these commands, and so that U.S. Southcom would be the commanding officer, and all of the subordinates underneath that for the entire region of South America, Central America, and the Caribbean.
Okay, and the diplomatic cables, U.S. State Department diplomatic cables. Can you please explain what your understanding? What is a diplomatic cable?
So a diplomatic cable is a diplomatic communication between usually between embassy or consulate employees between each other, including ambassadors, and then it can go all the way up to the Secretary of State in terms of the correspondence between a chargé d'affaires at the lowest level and the secretaries, the deputies and assistant secretaries of state, and the Secretary of State herself or himself, depending on the time frame.
And in your experience as an intelligence officer, are these communications generally classified, sensitive, or does it vary?
Yes, it varies quite significantly. I would say that the State Department certainly classifies a whole lot less documents than the U.S. military does. Most diplomatic cables are unclassified, but they tend to still have some be closely held, is the terminology that the government would use, the U.S. government.
Okay. I'd like now to speak about, and I'm trying to be specific. I'm following again on the Court of Appeal document C7. I'm now on page 4, and I'd like to ask some questions regarding WikiLeaks.
Okay.
So, when did you begin visiting the WikiLeaks website?
I think from my recollection, I visited the website after an instructor in 2008. basically said, don't go to this web page. And of course, I went to my barracks room and visited the site and never thought of it. I didn't think much of it at the time, and I moved on. It was basically, don't go to this website. I don't. That was the first time that I encountered that website, and I didn't turn to it for well over a year.
Okay, so so the reason why you went on the website was, how would you qualify the reason why you first visited the site? Curiosity, or?
Yeah, curiosity. Like why? Like, it's the instructor tells you not to do something. Of course, you're going to go do
it. Now, the Court of Appeal document, and I'm just looking for the exact line. I'm understanding you first visited in 2008, 2009. What led you to? Oh, sorry. What led you to choose to share information with WikiLeaks in particular?
So what led me to share information was I came to the decision in 2010 to finally disclose information that I felt the public should know, particularly about the wars in Iraq and Afghanistan, and the significant difference between what I had been seeing in Iraq and Afghanistan and what I was aware of in terms of like the historical information, like the facts on the on the ground reality of asymmetric warfare, and what was happening in Iraq and Afghanistan, and what was being reported on in the media and being discussed, in sort of our political institutions and our public discourse. And I found this to be very significant difference. So I made the decision to go to the Washington Post during my leave and submit the significant activities reports, as I recall, to along with a note that basically said, to whoever receives this, I wish you to publish this information that reveals the reality on the ground, reality of 21st century asymmetric warfare. And I tried to communicate with the Washington Post. I struggled to get in touch with a reporter. I also went up to, I basically returned to the United States in late January 2010, and I was attempting to do this. I took some time to try to reorient because I had other things to do. Like you get 2 weeks off for your leave, and you're trying to pack it with seeing as many people as possible and doing as many things as possible before you have to return back to theater. And I basically traveled and went out and about, and didn't have any success getting in touch with the Washington Post. I returned to Washington, to my home in the Washington D.C. area in Potomac, Maryland, and I I basically tried to go out to visit a journalist or reporter, and the largest snowstorm in quite some time happened to hit the region, and we lost power, and there was no ability to travel for, I think, 2 or 3 days. So I was essentially running out of time, trying to get in contact with the Washington Post, and I also made it a less less capable attempt at reaching out to the New York Times, sort of in desperation. And I also came up with this plan to go to the Alberton Communications Building in Virginia, which was right across the river from a bridge from me, to go to a website called Politico, which is widely known today, but at the time was a bit more of a blog upstart that I was very interested in, and basically running out of time. And I knew about this website, and I knew about the existence of this website and that they publish information. And running out of time, I decided to upload to them from a Starbucks from a Starbucks attached to a Barnes and Noble in nearby to my home, about a mile away, because we didn't even have power or internet, and so I found a Starbucks once the roads cleared up enough that I was able to drive again.
You mentioned having considered or Washington Post. You mentioned Politico.
New York Times.
The New York Times. Okay, New York Times. Thank you. My question was, and it's kind of a lead-in, had you considered other platforms or other means of sharing your message or your information before turning to WikiLeaks?
I did. I also considered sort of half-heartedly, because I was a web developer. I know how to build a website. I know how to build a set up a web server. But just time and logistical access, because it's the internet access while you're overseas at this time frame was the equivalent of 1990s dial-up. So it was bandwidth was an issue. Access to being able to upload large repositories of information was very difficult. And I considered posting it in different ways that were much more reckless, that I would say, which would be like to post to post it like on a website on a website all by myself, or on a torrent or something. I did consider these options.
Okay. And when you mentioned running out of time, are you? I just want to be clear. Are you referring to time because you were on leave in the United States from your post? That's what you. Mm-hmm. That's the time constraint that you are referring to?
Yes, absolutely.
Okay. Now, had you at any time, actually, I should just refer to this. Again, I'm on document C7. I'm on page 4. I'm in the 4th paragraph. And what the document states here is that she, being you, accessed a website run by the U.S. Army Counterintelligence Center, USACIC, that contained a report concerning the Wikileaks organization. The report stated Wikileaks was a threat to U.S. operational security, information security, counterintelligence, because of its public posting of classified and sensitive information. So my first question is, is that accurate? Did you in fact consult the website of USACIC in 2009?
No, not 2009. 2010.
2010.
This would have been I believe March timeframe. So this is after the uploads in January of 2010.
So you consulted the site after having already uploaded the information to WikiLeaks?
As far as I was aware, yes. Although I was, it was unclear to me whether or not publication would actually occur at that time.
You consulted the site, and is it accurate? Did you? I'm referring to the USACIC report. Did you read the report?
Did I read the report? Yes, I did.
Okay, and were you concerned at all about what the report stated about WikiLeaks?
Yes, I was. I had concerns, particularly about the. I mean, it seemed to be a very ill-informed report. It seemed to be quite alarming in terms of how it was written and the positions that U.S. counterintelligence was taking at the time. So I felt that this was extreme. I mean, it's an extremely problematic thing whenever the government starts to view, and acknowledge. I mean, in that report, it acknowledges that the First Amendment covers, even the counterintelligence agency was able to acknowledge, yes, First Amendment covers this kind of publication style, this kind of publication, this outlet, if you will, but still treats it as nefarious or dangerous in some way. And to broaden that scope a little bit in terms of like, if I recall in the document, there's other comparisons as well to be like, well, like the other journalistic organizations could be, could adopt this method and could become threats to the daily operations of the U.S. government, and particularly in the case of this document, the U.S. Army.
So in your opinion, having read that at the time when you consulted that report, you felt it was inaccurate, exaggerated? Are those
dangerous is the word that I would use. It's a dangerous position for the U.S. government to hold, to view outside journalistic agencies as threats to national security. That's my position.
Dangerous, but inaccurate, or just dangerous?
Inaccurate and dangerous.
Okay, and dangerous. Okay. Prior to choosing to share the information through WikiLeaks, had you considered raising your concerns internally? By that I mean within your. I don't know the breakdown of how the superior officer and all that. I'm not familiar with how the military breaks down in that sense. But my question is, had you considered sharing your concerns or voicing your concerns with persons in the military who were your superiors or commanders?
Yes. So, and I will. Do you mind if I expound upon the different means?
All means.
Okay, sure. What one means in terms of like raising concerns is through what is known as an Inspector General Action Request, or IGAR. This is a document. There's two ways of doing it. There's an informal and there's a formal. An informal complaint. It's not even cited as a complaint. It's just an action request. You're asking the inspector general of the U.S. Army in a particular office, a junior office, to enact an action. And so you submit this form, and you either sign with your name, which is an option. That is for a formal request, and then you. If you wish to not reveal who you are, you can refrain from identifying who you are and place that document into a particular box. I have availed myself in the past of Inspector General Action Requests. Interestingly, before and after the disclosures of 2010. So whenever I had submitted these kinds of things before, but unrelated to the information in the disclosures, I've had these things, and it's never ended well. There's an understanding in the military that if you submit complaints or whatever, there's three possibilities of something happening, and that is that you'll either face reprisal, which they're not supposed to do, but who, like your PFC, whoever, like who's going to listen to you. Then there's the possibility of it being like acknowledged but not acted on, and then there's the more mysterious one, which is known as File 13 in military parlance, which is where you take a document and you file it away inside of a shredder. So that's those are the kinds of understandings that at least in the day-to-day life, it may not be in the rules and regulations of how these things work, but that was my understanding. Then there is there were equal opportunity complaints, which I had submitted. Those are more for HR style in the civilian world, more human resources type complaints. I
apologize for interrupting you. There was a distortion, and I didn't catch what you said. What was the second method that you referred to, please? You started talking, and it distorted for me, and I didn't hear what it was called. I'm sorry.
Okay. The second means is the second means of filing a complaint is an equal opportunity complaint, which is it's very very much a human resources type complaint. It may or may not be relevant to this, but it was available as an option. I I have submitted EO complaints before. There's also the formal and informal complaint system. Another means of bringing things up to officers is like the more direct way, like bringing things up with a superior officer. I had done this on more specific occasions, particularly with respect to activities that I am bound by the non-disclosure agreement. I think there was one incident which is brought up a little bit in trial, which is the Iraqi detainees incident. But I don't feel comfortable like getting too much into that because I can't remember what is and is not within the bounds of the non-disclosure agreement. Basically I did go through and raise issues on occasion with with various superior officers, and I was either told ignored or told stay in my lane. These are more general. These are obviously the list of means. We'll stick to that. Members of Congress are available as an option. I believe that's under the Military Whistleblower Protection Act. It is available as an option. I did have communications with, and I knew my member of Congress at the time. My member of Congress is usually very responsive to things, but when I was raising issues, particularly and those are privileged information. Those are privileged communications. So I'm unaware of the U.S. military being aware of this or not. But I did go through to my member of Congress at the time, Democratic Congressman Chris Van Hollen, and who is now one of my senators in Maryland, and those communications were unresponsive, and it was a lack of reply or a lack of acknowledgement even. And this is from a member of Congress who was my member of Congress and I knew. Those are with respect to information that you're trying to have released publicly, there is the Freedom of Information Act. I did not go through the Freedom of Information Act myself, but I had seen both journalists and people trying to access records be denied records, or if not denied, then have delays in receipt of records that have gone as long as 3 to 5 to 6 years. So like the sense that I got is that on paper there were options available, but none of them were timely. None of them were taken seriously, and none of those options that were made available were available for the scale and scope of what I believed I was seeing, and the information that I had. These are systemic issues and systemic problems. These are not issues that you bring up with your captain. I don't know if that answers your question, sir.
I think just for a specification, yes, it does. With regard to your member of Congress, Mr. Van Hollen, when was it that you reached out or communicated or to your member of Congress regarding your concerns?
I do not know how many times that I have been in contact with my member of Congress, but this would have been. I certainly one of the things that I did whenever I was on leave during this time frame was I went to the physical office of in Rockville, Maryland, of my member of Congress. But again, those communications were privileged. The interactions that we had, I did have mixed interactions with my member of Congress, but on one occasion, I recall it was more physical.
Okay.
And to the extent that those communications are privileged, we expect that this line of questioning could go any further. Thank you.
I have no further questions regarding that subject.
Thank you.
Okay. Sorry, I'm just finding myself here. I'm moving along to page 5 of the Court of Appeal document, and I'm moving along to the last paragraph on page 5. I just want to read the first line, and then I'll ask you a question. It states that in early March of 2010, the appellant began chatting directly with WikiLeaks leader Julian Assange. So my first question, Ms. Manning, is that accurate? Did you begin chatting with the WikiLeaks leader Julian Assange in March of 2010?
I do not know. I was in communications with somebody. I do not know. It was a press association was the account name. I did not know, and I went through a period of time where I tried to speculate on who I was in communications with. But yes, I was in communications with some person that I believed to be at least associated with the website at the time.
And I'll jump in here to just point out, because we had discussed doing this earlier, that details regarding those conversations are in the Providence statement that's been filed at tab 9, and so just so that's clear for the member.
Sorry, Counsel Gill, I didn't. You're telling me to refer to the exhibit filed by counsels for Ms. Manning, Exhibit P9. Is that correct?
Yes, it's a Providence statement. It's a list of statements filed by the respondent in the course of her trial, and those detail, for example, when Ms. Manning is talking about the usernames, there's information there. So just for clarification's purpose.
Thank you. You can go ahead.
Okay. Well, my question. Were you at any time asked by someone from WikiLeaks to provide specific documents?
I don't recall that. I don't recall there being anything like that. It's in the record, but I don't. I mean, I was desperate to provide information, so it wasn't that I was being asked. It was more I had information and needed somebody to get it out.
Okay. Did you conduct any specific searches using search also, let's see, let me rephrase the question. Did you at any time perform a specific search in the documents that you were providing, looking for specific information?
I mean, that was my job, so yes.
Okay.
I routinely searched databases and I used a number of search engines and tools and search algorithms and some more advanced means and methods that I don't believe I can get into disclosure, but are very similar to Google, but just revved up quite a few notches.
Following having released the information, were you concerned about the potential of putting other persons in danger?
No, I was not concerned that this was the case. I believed that the information, particularly the categories of information that I provided, specifically with respect to the significant activities reports, those are not intelligence documents. They're historical records. They are X happened at this point in time, and have dated value, and and they're produced by soldiers on the ground at the time who are not intelligence personnel. So those. Significant activities reports are not intelligence records. So, and I worked with these records. these would come to me either through the Sydney database where they came from, or through a side channel, which is if it was at the brigade level, it was coming through a tool called CPOF before it was approved by division or corps. So we would have so these are more polished, the ones that that are put into this document are into these tables were more polished. They had been cleaned up, made sure that that kind of information, source identifying information, which junior soldiers shouldn't even have, like an infantry soldier shouldn't have. We had a separate channel and separate means in which to hold informants or contacts with sources. For instance, we had there's an entire compartment of information that is beyond the classification system in order to ensure that this information is not out there. And one of the ways in which we do that is instead of putting down people's names, we put down a source number, which refers you to a document. And then even if you're working with even if you're working with a source number in an intelligence, and this is even in intelligence reports, there would be a number associated with a sensitive source, not a name. And you could go to a file, but it would be held by a human intelligence officer who specialized in that. And and even though I could request for access to an identity, I was not allowed to take that information or write any notes down of that person. I could view who a source was and determine their validity and how much I could. But as sort of as an intelligence analyst, but I could not hold or take source identifying information. So for sensitive sources, I didn't have access to source names directly. I only through the curator of those identities. And the junior soldiers and enlisted people that are out in the field, they are not human intelligence collection soldiers or officers, and would not have access to that kind of information. So categorically, I understood that even though I had access to reports that had source numbers in them. Not names, source numbers in them. They are not inside of the significant activities reports themselves.
Okay. What about, were you concerned about that the information you were releasing could impact diplomatic relations between the United States and other countries, or?
I'm not a diplomat. I was very aware of the diplomatic and foreign relations of the United States in particular regions and particular locations. I do not work for the State Department. I have worked with the State Department. My concerns regarding that were that the documents that I had access to, the cables that I had access to, were specifically defense related or related to what is shared with the Defense Department specifically for the role that I held. So my understanding was that whenever it came to more sensitive diplomatic discussions and things between ambassadors and department secretaries, that kind of information is more closely held, specifically between. They have different designations. So these particular cables had a designator called SIPDIS, which was basically shorthand for SIPRNet distribution, which meant that it was shared with on the ground military personnel, specifically as a part of a sharing arrangement with the Department of Defense and the Department of State. And so the more sensitive types of documents, which I was aware of at the embassy in Iraq, I did not have access to things like no distribution or limited distribution. And before my disclosure of before sharing this information, I did do a search just to brush up on, just to check in and make sure that, I knew the different distributions and what they were for. So for this category of information, I did not believe would harm, but I am not, and as I stated at trial, I'm not a diplomat. I don't have that kind of expertise.
What about? Sorry, I did two actions at once. What about potential harm to, given that some of the information involved other countries, such as Canada? Were you concerned, or did you ever consider that it could affect other countries' diplomatic or international relations?
No, that's the United States does not, as a general rule of thumb, and I don't work for the United States anymore, so I can say this: the United States typically only cares about the United States. It does not care about the interests of other countries, even allies, typically, to be quite frank. And I would have had this in 2010. I probably would have held a very similar view.
Sorry. Okay, I'm just continuing. Small technical. Right. Okay. Okay. So I'd like to ask you some questions about how the information was transmitted. And I see. I'm not getting into too specifics. It's just more the process in general. And I'll be very careful in how I ask the questions, of course. Can you describe how you transmitted information to the Wikileaks website?
So there was a number of different methods that were used. I don't recall I went through the Providence statement in 2013, in January 29th, 2013. I went through the Providence, through a approved Providence statement in which I went through all of the different means and methods that I used. And I don't, I can't go through all of the different ones, but I don't. These were all, as far as I remember, every single one of them was electronic. These were electronic submissions, either through a submissions form or through a sort of an intermediary server, which I would log into, and I would upload it through sort of like a backend server tool to log into and upload. I don't recall the order or when off the top of my head, but it lines up with what's in the Providence. Yeah.
Okay. So specifically, did you download? Do you recall downloading information onto compact discs?
Not compact discs, but CDRWs. DVD-RWs. DVDs would have been more preferred because the large scale of documents. So CDs only hold about 700 megabytes, and I needed at least the 4 gigabytes of space to do this stuff.
Okay, so
sorry, I'm just going to jump in here. Just give me 30 seconds. I want to actually get the paper version of Exhibit P9, the statement made. Just give me a second, please, okay? Okay, thank you. Sorry about that. Go ahead, please.
So you were explaining that the DV has more data, more
DVDs. Yeah,
DVDs. Yeah. Okay, great. Thank you. Did you? Can you confirm whether you did you return? Is it accurate that you returned to your quarters to upload information onto the WikiLeaks sites?
No, there were more steps involved in that. So I returned to my quarters in order to hold the information. And so that information would be either on my computer or on a disk. I would try to, I would try to keep it as much as I could on the computer. But again, computers of this era could only hold so much information. My recollection is that sometimes these these documents would be on my computer for several days before I was able to submit them somewhere.
Sorry.
I'm so sorry. I'm just wondering if I can jump in here. Given that there is a lengthy list of admissions in the Providence statement from the respondent that are contemporaneous, that were not contemporaneous, but made in the context of her trial, and that those are quite detailed about the technical measures that she took at that time, the software that she used, the series of events. I'm just wondering, I understand, of course, that, you have the right to examine her on those events, but given that those are detailed in that document, I'm just wondering if it might be more expedient to sort of refer to that document or to accept those admissions as part of the trial record.
Okay. I'm just going to pull up the document.
Sorry, Madam Member, did you say something?
Sorry, I was on mute. I apologize. Yes, I was just asking Council Lashley if you wanted to respond to that. For what it's worth, I'm just going to give my 2 cents here. I would appreciate if we could hone in, if Minister's Council could basically hone in on some of the key information, although I know it's already contained in this document that I do have before me now and that I am consulting as Ms. Manning is speaking. I think it would be pertinent and useful to have just a general summary of how the actual disclosure took place at the time without going into unnecessary detail or at length in the context of this particular proceeding. Maid Lashley, if you just want to respond to what Council Gill has said, you can go ahead.
Yes, I'm sorry. I'm just trying to pull up the Providence, the document, so I can. And of course, I appreciate her suggestion in the interest of time and in the interest of not having to go through every specific detail since they are in a statement. I will pull up the document. I understand. Sorry.
I was just going to say it's at tab 9, page 172. Okay, that's helpful.
I'm sorry, would anyone object to the quickest break here? Just 5 minutes?
That's fine. That's not a problem. Let's take a quick 5 minutes, okay?
Thank you.
Mr. Bloom, in case I forget to mention it before the lunch break, it would be appreciated if you could verify with your witness as to her availability so that when we reconvene, we can kind of organize ourselves a little bit for regards to the timing.
I actually have emailed her. She's teaching tomorrow morning, so she's not available in the morning, but if needed, she can be available anytime in the afternoon.
So we'll come back to that subject this afternoon then, and
we'll see where we get today.
Ourselves accordingly. Okay, very well. So I think we're just waiting for Mr. Lashley. Oh, yeah, Mr. Lashley.
Okay. I did something. There we go. I'm back.
Okay. Yep. We see you. We hear you. Well, now you're on mute.
Done.
Yeah, there you go.
Yes.
So you can go ahead and continue. And sorry, before we break, basically, I was just asking you if you had anything you wanted to say in answer to what Counsel Gill was suggesting. As I said, the panel would appreciate if you continue to a certain extent with your line of questioning because we can get a general idea. And then if more detail is required, obviously we can refer to the exhibit that was provided by counsels for Ms. Menny. Okay?
Okay. Thank you. So, okay. So, in regards, again, I'm returning in regards to the process of uploading the documents or the information. Did you ever at any point upload to WikiLeaks from your workstation?
No.
No. Okay. And why?
So the workstations that I used, I had multiple workstations, but they were all air-gapped from each other as well. So they are connected to a network, but that is an internal Department of Defense network. And there's another network that is internal to the intelligence community. And then there is another network, for like diplomatic communications and things. So all of these things came from all these things came from my workstation. Specifically, it came through, didn't have internet access. So there's no access to the outside world. They are air gapped. They're separate networks.
Okay.
So you have to.
Okay, so for those of us who are not familiar, air-gapped means it does not have access to general internet, to an external internet that we would have access to.
Yes.
Correct? Okay. Thank you.
Thank you. Okay. Did you at any point install or use the wget computer program? I have to program or software. Are you familiar with wget?
I use it every day. I use it every day, multiple times a day.
Can you tell us what it is?
So wget is a download application. So it is a command line application. So it runs as opposed to like having a window open in which you click buttons or anything. You type in a command and you give it a set of instructions, and it downloads files or documents, and it can be programmed to download multiple files or documents. It can be it can download damaged or hard to where a connection is spotty, and it will download sections of a document. So it is essentially a downloading tool. It downloads documents or files or large or small files or multiple files from different points on what is known as a hypertext protocol network. So basically the internet, but like also it doesn't have to be the internet. It can be an internal version of the internet.
Okay. And did you use this download application to download information from your workstation?
Regularly, yes.
Okay. And did you use it to download the information that you would later transfer to WikiLeaks?
A portion of it, yes. I believe the diplomatic cables were downloaded using wget.
Okay. Now, to use wget, did you have to install the software onto your computer? How does it work? I don't know the computer. Do you install it on your computer and then it?
There's nothing. You just put it on. Like it is a standalone tool. It is known as in computer parlance, it is a binary application. So like it is a .exe file if you're on Windows, and you just run it. It works, and you give it command line. You tell it like the web. You go wget.exe address, and it will download without needing a browser or anything.
Okay. Now, you mentioned not needing a browser. You mentioned it being used for downloading large amounts of data. Are these reasons, and among others, why you chose to use wget?
The reason I use wget is because I use it so frequently. I use it every day. I use when you're, for me personally, like there are two reasons why I use wget on a daily basis. One is to download things that are on the server. So if I'm in a Linux environment and I'm on a server, it doesn't have a windowing system, so it will just be a command line that I remotely access to, which we had servers in our shop, so we would have to log in to be able to access through the command line to be able to log into these things. And now during doing the work that I do every day, I have to log into these things, and you don't have the benefit of a browser, so you just type in wget or curl. Is another thing that does the exact same. Curl is the exact same tool, basically does the same thing. And yeah, you do, or you can use it if I think it's safer than a browser, because if you go to a website and you download a file, you go to this website and you don't know what's on the website, trackers, all these different nefarious things that are on the browser. Like if you're, like ads and trackers and things. So if I want to download a file, but I already have the address of the file or the website, I can just type in a wget command and save myself the need of exposing my computer to a significant number of internet threats.
Okay, but specifically in 2009 or 10, when you were downloading information from work, is that why you chose to use wget?
Yes, it's a frequently used systems administration tool.
Okay. Okay. I'm sorry. Do you have? I'm sorry. I'm just. My co-counsel has a question. Small computer issue, and it's resolved. I'm sorry again for the delay.
Okay, take your time.
Fortunately, we're not as good with computers.
No problem.
Okay. Introduce yourself.
I just want to ask you a very specific question concerning CertNet.
Yes.
Why did you ask the help of your contact at Wikileaks to bypass the CertNet security system?
Sorry, I'm going to object to that. Can you provide a source for that claim, or is there a document you're referring to, counsel?
Yes, C7.
Okay, and what page, please?
I believe it's page 5.
Okay, and the line.
The last paragraph.
Last lines of page 5 of C7. In early March 2010, appellant began chatting directly with WikiLeaks leader Julian Assange. Appellant asked Assange for help in bypassing the CertNet security systems.
Perfect.
That's what you're referring to, correct, Minister's Council?
Yes.
Okay, so just so we're clear, that's where the question is taken from that particular excerpt from C7. So
Perfect.
repeat the question, please, Med Barrett, if you can just repeat the question. Thank you.
Yes. Why did you ask the help of your contact at Wikileaks to bypass the SIRPnet security system?
I had already had access to the SIPRnet security system. I used it every day.
Sorry, the sound is being distorted a little bit here. Repeat the last sentence, Ms. Manning, please.
Yes, I don't understand the question. I had access to I worked just every day in my office. I had access to everything.
It said on page 5 that the appellant asked Assange for help in bypassing the SIRPnet security system to allow the appellant to anonymously navigate the SIRPnet system.
The question doesn't make sense. I had access to everything that I worked with every day, and I was not charged with bypassing any systems.
Maybe we can just pull up the Court of Appeal decision on the screen. We can take care of it.
By we, do you mean you?
By we, I mean we. By me, I mean my co-counsel. Because I can't figure out sharing either.
Let's see. So if I understand correctly, we're here in early 2018, appellant and chatting. Now, just to be clear, my understanding is that this is factual context provided in the context of the appeal reasons. This was not related to the offenses alleged by the minister in this proceeding.
So, do you have an objection, or it's just an argument that you're raising at this point?
I think I'm asking you to clarify the relevance of this question.
Okay, if I could just jump in here, counsels, I think we should start by asking, because the assumption being made by the minister is that this statement is accurate. Perhaps we should start by asking Ms. Manning if this event actually occurred, or if this as it's stated here, if it actually happened, or if she's confirming that she actually did ask for help in bypassing, because we're assuming that this information is accurate in asking her that question in the way it was phrased. So, Meg Barrett, maybe if you could just rephrase the question, please.
Yes. Do you remember, or at your knowledge, is it something that happened that you would have asked your contact to help you to bypass the security system of SIRPnet?
I don't understand the question, but from what I understand, the reason I don't understand the question is because I had access to everything. I had access to everything on the network. I had access to all of the documents and everything. I did not need.
At any point, did you try to cover your tracks or try to access anonymously?
I mean, it's very difficult to do that. Everything goes through the shop. Everything is every single workstation that you use in Iraq, that we used in Iraq, is assigned to us. If I could foreseeably use somebody else's password or use a workstation that was not my own, but I don't. It would, like, no matter what, it was going to be. There was always going to be, in the forensic trail, it was always going to point to me. That's why I don't understand the question.
So it's my understanding you don't know where the information comes from.
It doesn't seem relevant to the disclosures, which I believe that's what you're trying to get at, right?
Yes.
Yes. I did not need to ask anybody for access to systems that I already had access to.
Okay. Thank you.
Right, Ashley, did you want to resume your questions?
Yeah, I just have a few more questions. I can't get. Can I get back to the screen?
Yeah.
Just
Just about
Yeah, I'm sorry. Oh, but actually, if you want to go to page 7, oh, I'm sorry. Okay, it's okay. I'll read the part that I'm referring to anyway. I'm sorry for the delay. Again, okay. So, Ms. Manning, I want to ask you a question. I'm still in the area regarding the process or the I'm not sure the lingo, but of how documents were transferred. And I want to refer to. I'm still in the Court of Appeal document. I'm on page 7, and there is a reference here to a chat. Now,